Today we are going to deal with constitutional bench judgment of Supreme Court, whereby the Supreme Court had decided the notification issued by central government acting under subsection 2 of section 26 of Reserve Bank of India Act 1934, whereby 500 and 1000 notes were ceased to be a legal tender with effect from 9th of November 2016. The said reference arose before five-judge bench of Supreme Court, in which the reference was answered by a majority of 4 judges, and the answer was that first the Supreme Court answered that power available to the central government under subsection 2 of subsection 26 of the RBI Act cannot be restricted to mean that it can be exercised only for one or some series of banknotes and not for all series of banknotes. The Supreme Court said the power can be exercised for all series of banknotes merely because on two similar occasions the demonetization exercise was by preliminary legislation. It cannot be held that such a power would not be available to the central government under subsection 2 of section 26 of the RBI Act. The purport of these findings has to be seen in the context that an argument was raised that earlier when demonetization was happened earlier 2 times before this demonetization, in those cases only some series of particular note were banned, and today by way of this legislation or notification the entire series of 500 and 1000 was banned. So it was an argument from the side of petitioner that was negated by the Supreme Court while answering the first question. Now secondly, the Supreme Court had held that section 26 of the RBI Act does not provide for excessive delegation inasmuch as there is an inbuilt safeguard that such power has to be exercised on the recommendation of the central board. As such, subsection 2 of section 26 of the RBI Act is not liable to be struck down. The findings were given when the argument was raised that this power under subsection 2 or section 26 is a result of excessive delegation. So therefore it has to be struck down as ultra virus. But Supreme Court had held that as there is an inbuilt safeguard and such power has to be exercised on the recommendation of the central board, therefore it cannot be struck down. Then the third argument was raised that this is suffer from flaws in decision making process. That plea was also negated, saying that there is no flaw as such in decision making process by the central government and central board while recommending demonetization. Further, it was held that proportionality test also is not being properly followed while doing demonetization by the government. It was held that the impugned notification dated 8th November 2016 also satisfied the test of proportionality, as such cannot be struck down on the said ground. Then the another plea which was raised before the Supreme Court was because the the window on which the exchange of notes while the impugned notification was open was very small and it was unreasonable. So it was held by the Supreme Court that the window provided for exchanging notes by the people cannot be said to be unreasonable. Then lastly it was answered that the RBI does not possess any independent power whereby under subsection 2 of section 4 of the 2017 Act and that is not in isolation of the provisions of section 3 and 4 thereof. So therefore it was held that demonetization notes beyond the period specified in the notification issued under subsection 4 of the 2017 Act cannot be entertained. So if we would see the notification and the subsequent notifications which were issued after that, it was clear that those notes of 500 and 1000 for individual were allowed to be exchanged till 30th of December 2016 subject to certain conditions. Initially there was a limit of rupees 4000 for such exchange, and it was held that after 15 days it would be reviewed by the government by the notification. And further, when the deposition was concerned, that the amount can be deposited in the account, it was 50,000 for non KYC, and rest there was no limit. Then certain relaxation was also given, that restricted banknotes could be used even after that period for certain period for making payment in government hospitals, pharmacies, railway booking criteria, for purchases made at consumer cooperative stores, milk booths, purchase of petrol, etc. The said relaxation were valid till 11th of November 2016. Then the 2017 Act, which I have just spoken, which was the last reference and on which the last finding was given by the Supreme Court, that was an act enacted by the Parliament, that is Specified Banknotes Cessation of Liabilities Act 2017, which was referred as 2017 Act. And the very purport of this act was that to make those banned notes to be ceased to be a legal tender in view of the notification of Government of India of November, and those notes would shall cease to be liabilities of RBI under section 34 of the RBI Act, as every legal every bank note is a liability of an RBI to make payment. So therefore this particular act which came in 2017 erases the liability of RBI qua those notes which were covered by the notification of 2016 and which were not exchanged or deposited in the bank account, as the case may be. The Supreme Court has also held that 52 days period which was given for exchange of banknotes was reasonable period. So therefore there is no question to be the period to be unreasonable, unjust or violative of the petitioner's fundamental rights. It was held if the period was not limited, then those high denomination banknotes could be circulated and transferred without the knowledge of the authorities concerned from one person to another, and then any such transferee could walk into the bank or any day thereafter and demand exchange of those notes, and in that case the entire exercise would be redundant, the entire purpose would be defeated. Then the plea of proportionality to struck down that 8th November 2016 notification was negated on the reasoning that restriction which were imposed has a direct and proximate nexus with the objective to which the notification sought to achieve, that is to curb the black money, to curb the fake currency, to curb the money circulating in the economy which is not accounted for. It was held that the notification was used for the purpose as fake currency notes have been largely in circulation, and it was not easy to identify those notes with genuine banknotes. Further, that those high value notes were used for storage of unaccounted wealth, which was evident from large cash recoveries made by law enforcement agencies before the notification. And thirdly, that fake currency which is used is financing subversive activities such as drug trafficking and terrorism, and which is in turn is causing complete damage to the economy and security of the country. So therefore that proportionality test was upheld while holding that notification is able to achieve the purpose for it was issued. So therefore it cannot be held that it is ultra virus and falls into proportionality test. Now, as the power which is being exercised by the court while assessing the challenge to the notification is called judicial review. So therefore the Supreme Court held that judicial review of the notification is not made out for the reason that when the decision of the government is based on the relevant facts and circumstances or based on expert advice, the court would not be entitled to interfere, and it would interfere only when it would found that action of the executive is arbitrary or violative of any constitutional, statutory or other provision of law. And once it is the government forms its policy based on a number of circumstances or based on experts' opinion, then it should not be interfered with except on the ground of palpable arbitrariness. And it is also settled that the court gives a large leeway to the executive and legislature in matter of economic policy, as it is not a function of court to sit in judgment over such economic policy which has been left to the discretion of the government of the day to decide in such matters with regard to prediction of ultimate results. Even the experts can seriously err and doubtfully differ. Then in that case also the court can certainly be not be expected to decide them without even the aid of experts. So therefore while upholding that notification banning the notes of 500 and 1000, it was so held by the Supreme Court as far as judicial review is concerned. Further, the Supreme Court held that the record of the case reveals that RBI and central government were in consultation regarding that for a period of 6 months when the notification was issued in 2016 November. It was held by the Supreme Court that the record is also reveals that all relevant or information was shared by both central board as well as central government with each other. So therefore it cannot be said that there was no conscious, effective and meaningful and purposive consultation while uh, giving this impugned notification by the government banning the notes of 500 and 1000 as a legal tender with effect from 9th of November 2016. Therefore, the Supreme Court held by a majority of 4 judges in constitutional bench that this court should defer to legislative judgments in matter relating to social and economic policies and must not interfere unless the exercise of executive powers appears to be palpably arbitrary, as this court does not have necessary competence and expertise to adjudicate upon such economic issues, and it is also not possible for the court to assess or evaluate what would be the impact of a particular action, and it is best left to the wisdom of the experts, as in such matters it would not be possible for the court to assess or evaluate what would be the impact of the impugned action of demonetization, as the court does not possess the expertise to do so. The Supreme Court also held that the notification had a nexus with the objective, as I stated above in my video, to be achieved. Then, merely because some citizens have suffered some hardship would not be a ground to hold the impugned notification to be bad in law. As I already told that this was a constitutional bench, which 4:1, the 4 judges in dismissed the petition and one Honorable Judge Justice Nagaratha has given her dissent opinion, which I would also deal in this video, which is, now it has to be seen what was a dissent. The dissent was that it was held by Justice Nagaratha that central government possessed the power to initiate and carry out process of demonetization of all series of banknotes and of all denomination. But in the question, because the power was exercised under section 26 subsection 2 of RBI Act, which has to be initiated by central board, so her lordship had held that demonetization by the central board cannot be for all series of banknotes of all denomination, and it could not be recommended by central board. So her lordships dissented on that. As in the present notification, the power exercised under section 26, which can be done only by central board by way of recommendation, therefore it was held in dissenting opinion that all 1000 and 500 notes of all deno- both denominations of entire currency in circulation cannot be recommended by the central board, as this power can be exercised only by the central board and not by the central government, because central board would recommend to the central government under subsection 2 of section 26 of the Reserve Bank of India Act. Her lordship held that central government has a power to demonetize all notes of all denominations, but that power, plenary power with legislature, can be exercised only by way of issue of uh, another enactment for that, and not through issuance of notification under subsection 2 of section 26 of the RBI Act. There has to be a plenary legislation regarding that by the legislature, by the parliament. It was further held by her lordship that if it is held that central bank has power to recommend demonetization of all series of all denominations, then it would be a case of excessive vesting of powers with the bank. Further, it was held by her lordship that in this case the proposal for demonetization arose from the central government, and therefore it could not be given effect to by way of notification as contemplated under subsection 2 of section 26, as by exercising that power only the board can recommend for demonetization to the government, not vice versa. Ultimately, in dissenting opinion of a single judge, it was held that impugned notification of 8th November 2016 is unlawful, as for the reasons I have just stated. As such, it was struck down by dissenting. So, as we know, only a majority opinion, which is a judgment of the Supreme Court, as four judges speaking through Justice Gawai had given the majority opinion that is binding and law of the land. As such, the validity of the notification issued for demonetization of 500 and 1000 rupee notes, all the series notes, was upheld by majority of four judges. Dissenting by one judge, I have given my views that why that single one learned judge of the Honorable Supreme Court had dissented. And this is, and thanks for watching this video.